Clark, that's the gift that keeps on giving the whole year.
Well, hello, everyone, and thank you for joining.
Extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it. Extremely.
I'll answer yes if that helps.
Provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not served.
You are attempting to disrupt with asking questions like this.
I'm here concerning this matter as third-party intervener.
I don't know if the mics are on.
It should be, yes.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever. Oh, that was all loud, sorry.
So
Nobody reported on record about me being bruised up and having to get bandaged up. And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever. And that by refusing to answer, that is a tacit agreement by you, Your Honor, which you understand what that means. I know you do. You said the individual you spoke with seemed out of place and disoriented, like he didn't know where he was. Would that be fair to say?
That's correct.
And how would you characterize disoriented?
You just seemed very, very nervous and that you didn't know where you were.
Who's you?
You had specifically said, I don't know where I am.
Who's you?
Or where am I specifically?
So disoriented would, from your perspective, be exactly what? Who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
objection,
Grounds.
legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You are
move to
aware of
strike.
that, right?
Go ahead, Attorney Upper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a legal conclusion in any way.
The court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement, and the question asked, for all of the reasons indicated by the stated, also is a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted.
He didn't just object, he definitely objected.
You interrupt. You don't wait for anyone to finish.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The court will let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that the true nature and cause has not been presented to me, that I don't know what the true nature and cause of the charges are? Grounds for the sustain, Your Honor.
Next question.
So I can't get no grounds. Okay. Any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 906.11, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under 906.11, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this
They're
witness.
going to keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're going to keep
please.
coming up.
Under 906.11, sir, please move on to a new topic.
They're going to keep coming up.
For the cross-examination, I will.
Anything else stick out to you about that day?
So there'd been the subpoena sheet that would have had, your name and, a number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
Objection, argument sustained.
Sustained.
Sorry.
Are you willing to expressly waive that right on the record right now?
I'm not going to expressively waive anything. I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I need to make an
I
appropriate record.
just told you that I don't understand the questions you're asking. What do you want me to do? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same. It's the same document. That was
Reference to
accepted for value,
the-
returned for value yesterday. The same document. Now, please go back into the other courtroom. Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court. Sorry, was there an objection
Yes.
on the basis of the objection?
Relevancy.
It is relevant. It is received, 51B.
The objection be noted for the record, Your Honor.
It already has been.
I want to
Stop interrupting me.
be here. You were quiet. I didn't.
Mr. Brooks,
Respect for them would be
Mr. Brooks,
telling them the truth.
stop.
all right. Well, bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes. It is my right to do so or to not do so.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking. It is frivolous, though. That's gonna get pressed every time. So I have yet to prove subject matter jurisdiction, any jurisdiction at all, rather.
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. I apologize to the witnesses. A little emotional right now for me, so. I don't understand.
All right? You willingly waived your right to an attorney. I made all of those findings, so we will go
You
forward.
made those findings,
I
but
am
they-
not obligated to answer questions.
You made
when you
those
ask me
filings.
questions, I'm going to mute him.
I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
This is alarming, to say the least.
Let's revisit this. We'll read this infamous Reddit post. It says this was posted by Anonymous Brooks Juror 19. Anonymous Brooks Juror. That's what it says. I am a member of the jury on this case. Here are my thoughts on the trial and on this subreddit. So, to start with, I obviously shouldn't be here. I'm not allowed to look stuff up about this trial or really have any connection with the internet, but nobody actually follows sequestering rules anyway. Hence, I am obviously posting anonymously. Accidentally wandered into here a few days ago from the subreddit drama thread on my main Reddit account. Here is my opinion on the trial. First off, I think it's pretty obvious due to chain of custody that the defendant is in fact Mr. Brooks and he did do it. However, I've had throughout this trial doubts about various aspects of this case. The judge is clearly biased against Mr. Brooks. I got that feeling from when we were in the room, and my eyes have opened to how she acted towards him when the jury was out of the room. Well, how would you know? How would you know if you weren't in the room? Clearly, she is not an impartial judge, and has been trying to belittle, demean, bully, and pull procedural tricks on him fairly frequently. I had my doubts already, but the subreddit has shown it to me clearly. All right, I got this off of Mashable. Secondly, Mr. Brooks has clearly not been given the chance to plead his case in front of court. He has been silenced and mocked every turn. While he may be a bit loud or crass at times, I still believe his side deserves to be heard. Now, I do have significant doubts about subject matter jurisdiction. I didn't understand it when discussed in court because the defendant was repeatedly silenced. But I do understand now, thanks to this sub, and I agree that subject matter jurisdiction is a great concern here. This subreddit has made me aware of jury nullification, and I am very grateful for that. Overall, I'm not sure what I will decide. I'm not educated in law, and I have to admit I'm biased against the defendant for the horrible acts he did. However, it is also clear that this trial is a complete kangaroo court. Mr. Brooks has not been allowed to try and prove his innocence, subject matter jurisdiction, or explain the circumstances surrounding the event. It's hard to imagine what could justify it, but we just can't know because of this trial. For these reasons, I'm torn between locking him up and throwing away the key or jury nullification. Both have arguments for and against them, and I'm not looking forward to choosing. I am mostly writing this to help myself process my thoughts on this, but please let me know what you think.
Provided to me, which was an email, and then the attachment, the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial. Of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will leave that for law enforcement to determine, and of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted. And I hope we have the copies for the parties. And we'll provide those. Go ahead.
I'm making sure you was
Go ahead.
first. What is this?
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
For the record, I accept for value in return for value these documents. I'm confused.
At this point, sir, I'm providing the information. I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made.
Was this? Oh, I'm sorry. Go ahead. Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. When we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system, and I simply said, obviously, that information needs to go to law enforcement. I haven't seen it, haven't reviewed it. Their forensic unit is handling the investigation, to my understanding. Attorney Upper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. In viewing the content of the posting, We question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Can I say something, Your Honor?
Go ahead.
Just briefly skimming through it, I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light. I will say just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. This is no other way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Well, I mean, it's pretty obvious that this would come from somebody who's actually, I think it's pretty clear. I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here and these case laws and
What's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
relief.
Relief.
What are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue was put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever this thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room, they got certain feelings from when they specifically refer to themselves and a group. That would be we, plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, that this is clearly someone close to the case. And because of that, it still has to be I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks, and even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done. Something. And if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at, if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, and all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
All right. With all due respect, Your Honor, I hope y'all really enjoyed that because we needed to get that one out this week. Ooh. Y'all have a great week.